morning, everyone. This is Wanda Johns with the Healthcare Authority's Division of Behavioral Health and Recovery. I apologize for the delay getting started this morning. We had some technical difficulties launching the webinar. I hope you're all able to hear. If you have questions during the webinar, go ahead and type them into the question pane or raise your hand and I may be able to unmute you, or you can type them into the chat box. We're especially fortunate this morning to have Nick Yuva with us. He works for the Department of Commerce. He runs the Landlord Mitigation program, and it's done some great things to incentivize landlords and protect landlords when they rent. So looks like he's ready to go, and I will turn it over to Nick.
Hello, everybody, and welcome. Thank you for joining us. As Juan stated, it's great that everyone's on board here. If anyone's been paying attention to the legislature lately, the Landlord Mitigation Program is getting a lot of attention for some new measures coming up this year, but it's already been a massively successful system. It's been in place for, well, going on almost 2 years now. I'm going to show you first off the basics of the Landlord Mitigation Program to ensure that we're all on board and understand the ideas behind it and how it benefits folks that are in need. The Tenancy Preservation Program as well, and then we'll talk about the new legislature that's being discussed now that will have an impact on these programs and potentially your clients as well. So I'll try to go through this and keep an eye on the comments, but I'll probably address all the questions at the end of the presentation. But Commerce is responsible for the Landlord Mitigation Program. We have many, many different programs throughout Commerce, the largest bulk of which has to do specifically with housing and homelessness prevention and homelessness programs. The bulk of that falls under HAU, and specifically the the office that I work with Jeff, who's online as well, in the Office of Supportive Housing. They hired me. I'd never worked in public sector before this, but they hired me because I had a background as a landlord, and they felt that I could speak to landlords on an even keel. I have over 20 years experience working for multiple companies, got my property manager's license in Oregon, started my own property management company in 2005, got my ARM, which is a national accreditation, in 2012. And yeah, I spent an hour with that tiger in Thailand, as well as some elephants up the road. I spent half a day with the elephants, which was fantastic. The point of the tiger slide is chase your dreams if you can. It's worthwhile. Senate Bill 5600 became effective last year. This is the newest actual executed program in the Landlord Mitigation Program. This will affect more people as time goes on, as this is not restricted to low-income households, but this is an eviction prevention program that extends an interest-free loan with no specific deadline to tenants that are facing eviction. They'll have to go to court and meet with the landlord and have the judge agree with them that they're low income or in a financial hardship. That's where the folks that are not listed as low income can qualify for this program. And if they do, then the judge could sign off on the order, giving them the ability to borrow the money from Commerce. We don't have a collection agency here, so we're not going to chase them down for the funds. However, if they are awarded the funds, they're not going to be eligible for the program again until the initial loan has been paid back. Now, these funds will go straight to a landlord. They're not going to go to the tenant, so the landlord does have to do the claim and file the paperwork, but it's a fairly simple process. In fact, my approval rate is much higher on this program than on the Landlord Mitigation Program, which protects landlords from damages caused by tenants. So the tenant is always the party responsible to repay the court when these funds are paid out. Again, we're not going to chase them down, but they're not going to be eligible unless they repay. Commerce will send the payment directly to the landlord. The landlord can no longer pursue legal action for the monies claimed. The amount of the claim is going to be dependent on the judgment. So if the judgment is awarded to include legal fees, late charges, rents, and maybe some other costs that the landlord has included in that, and the tenant agrees to that, and the court signed off on it, we're going to pay that entire balance so that the tenant's not left with the balance after the fact. Now, payments can be delayed up to 4 to 5 weeks right now, so there is a time period where the landlord's going to have to rely on a guarantee of payment that I will provide to them once I reviewed the claim. So there's some convincing on the landlord side that as long as they're patient, they'll get the money from Commerce, but they can go on and just start a new month's rent with that tenant the following month. I would not encourage this for tenants that are chronically late, ones that will be right back in court the following month or even 2 months after. This is really for the folks that are willing and able to make an effort to remain in their units, so long as they can get over that hump and get that little extra push to get them on the right path financially. Now, this program is separate from the Landlord Mitigation Program in the eyes of Commerce, although in the law itself it is written into the same RCW, and it does share the funding source as the Landlord Mitigation Program, but the qualifications are slightly different. For this one, we need some court documents signed off by a judge. That's going to include a stipulated agreement or a writ of restitution, which is the judgment for the possession of the unit. But if we get that writ of restitution, we absolutely need to have a stay of action, which protects the tenant's rights while the claim is being processed and the funds are being delivered to the landlord. Without that stay, I can't approve it. Payment agreement with the tenant ledger. This is the other way that the landlord has access to this. If they go into court and enter into a court-appointed payment arrangement, the tenant and landlord can agree to come and use the funds from Commerce if the tenant is unable to maintain that payment agreement. So say they made a first of 3 payments. If they made the first one but they missed the second one, the landlord can then claim through the TPP fund for the remaining balance, and that's why I need the ledger on there. Either must include the language from the ESB 5600, and that language states that the court has found that the tenant is either low income, low resourced, or is in a financial hardship. It's a very simple paragraph, and it can be written into even on a stipulated agreement. The tenant acknowledgement letter is required. That's available on the website. This states the amount that should match the judgment and that the tenant accepts the responsibility for the monies borrowed from Commerce. And then you complete an online claim form, just like the Landlord Mitigation Program form. It takes about 10 minutes, and you can upload all the documents right onto it. If a tenant is not available to sign, if, for instance, they have the payment arrangements and the landlord can't get the tenant to answer the phone or come in the office, there is an absentee tenant form. It does require some due diligence on behalf of the landlord. They're going to have to show documentation that they made an attempt to contact the tenant. But that's a fairly simple process, but it does take a little extra time, but that form is available as well. And then the statewide vendor ID number is required on all claims, whether it's Tenancy Preservation Program or the Landlord Mitigation Program. The statewide vendor ID number, most of you are probably familiar with this at this point. This is a payee number, a registration that protects your information for public record disclosure, as well as identifies how you want to receive payment from the state. It's free to apply. Right now, we're looking at a 12-day turnaround on new applications. So we encourage landlords to go out and get this in advance so their funds aren't held up, because I can't process a claim without it. This presentation is primarily designed for landlords. If there are landlords out there, I'm really happy to have you on the call, but if not, you can use this as a tool when you're speaking to landlords for the liaisons. There are 2 studies that were done, one in 2014 that showed that the average turnover cost was $2,811. That's a very low number compared to where we are now, especially in the King County and Spokane areas. But in 2016, a National Center of Housing Management did a study that showed that subsidized tenants remain in their units 22% longer than non-subsidized tenants. When you take these numbers at even these low rates and you spread them across a 50-unit community with average rents of $1,200 per month, that could potentially earn the landlord an additional $18,500 if they just switch over to renting to subsidized tenants. Now keep in mind that this is scalable and that's going to change, and of course the numbers are different. I know that my average claim amount is kind of fluctuating between $2,500 and $3,000 after the deposits have been paid. But the 22% fewer turnovers is staying pretty steady at this point. And then on top of that, if they're renting to subsidized tenants in the state of Washington, they have the Landlord Mitigation Program, which acts as an extra barrier of security for that landlord. As average security deposits range from $500 to $1,500 at the low income range. At the market range, they're matching. They're typically about equal to a month's rent, which we'll talk about some of the legislation that's coming in that's discussing even that in a bit. But when these damages exceed those security deposits, the landlords have typically been left with two options. The first is to go get a judgment, which costs about $1,500 for a landlord, against that tenant, and then to hand the money off to a collection agency that may receive the funds back, and if they do, they're going to hold back 50% or more of everything that they collect. And when we're talking about low-resourced or low-income tenants, they're not likely to even get that much. But with the Landlord Mitigation Program, we can help them get all of that back without getting a judgment and without hiring a collection agency. The 2018 Landlord Mitigation Law became effective on June 7th of 2018. This is the program that offers compensation or reimbursement, I should say, for repairs to damages caused by subsidized tenants. This also offers an incentive for landlords to make repairs to pass HQS inspections. Who qualifies? Any landlord that's rented to any tenant that's received any form of subsidy. That could be a one-time Catholic charity subsidy, for instance, for eviction prevention. That could be a short-term rapid rehousing subsidy for 3 to 6 months. That could be a housing choice voucher, which is more of a permanent subsidy. Any payment that's received by the landlord on behalf of the tenant for rent from a government or nonprofit agency is considered a subsidy under the law. Except, and this is the only exception, are the properties that are owned and operated by a housing authority. So I talked a little bit about that $1,000 reimbursement for making repairs to pass an HQS inspection. If a unit's failing an HQS inspection, typically it's for a broken outlet cover or missing GFCI, and those repairs won't qualify for this. However, if they have to, say, as an example, replace 2-prong outlets with grounded 3-prong outlets, that's a costly repair. Most landlords may consider not doing it and just renting to someone easier to put in the unit. But with this program, they could do it, get up to $1,000 in reimbursement for making those repairs, and on top of that, we'll give them up to 14 days of lost rent for taking the time to make those repairs. This will help them pass the inspection, put the subsidized tenant in the unit, and so they'll receive on a prorated form. As an example, we use we'll say the move-in was delayed by 12 days, and the rent is $1,175 a month. Well, you'll see a breakdown to $38.63 a day, which means that they'll get on top of that $1,000 reimbursement an additional $463.56 in the form of lost rent. So this can really incentivize landlords to just go ahead and do those repairs or modifications that they're going to have to do eventually anyway, but at least they can make some of the money back in a sense. Now, before we jump into the big portion, the $5,000 reimbursement program, it's important to understand that landlords do face a risk when they do this, and that is that once they receive funds from this portion of the program, that landlord is no longer eligible to pursue legal action against the tenant for damages in the future. And damages is a tricky term legally, but I'm not going to advise anyone on this, but I will say that I would encourage they talk to legal counsel before they start pursuing any type of financial loss against that tenant if they've received funds from the Landlord Mitigation Program. Landlords can file many claims throughout the tenancy. The minimum of each claim is $500, and the maximum of all claims cannot exceed $5,000. When I go to a presentation with landlords, I make this a public question. I put it out there and ask how many landlords are doing periodic inspections, and typically about half the room will raise their hand. I'd prefer to see the whole room raise their hand. As a landlord myself, I would be in those units every 6 months looking at it just to see if there's any preventable maintenance that could take place or deferred maintenance that needs to take place. Sometimes subsidy providers will offer their own inspections periodically or by request. Subsidy providers are fantastic. As a landlord, I used to rely on them to help me with tenancy issues simply by calling them in to ask them to do an inspection if they did them. And either one will help prevent finding this at move out. This is a photo from an actual claim. The catch here was that the landlord was not doing periodic inspections. This tenant had a water leak in the kitchen, and she decided to repair it herself. And in doing so, she pulled out all the cabinets, found that the floors were damaged, pulled up the floors, saw the subfloors were damaged, pulled up the subfloors, and then, of course, was low-resourced and couldn't make the repairs, so she lived with this by what the landlord said for about 6 months at his estimate. And that's because the tenant didn't go to the landlord to talk about it, and the landlord hadn't been in the unit to inspect it, so she was left in this condition for several months. But finding this it's uncommon, but it's not completely unthinkable. It does happen. Jeff, who's on the conference here, has seen many of the photos I've received, and I've received some that are even worse than this. But the move-out is the most expensive time during a tenancy for a landlord. So I do encourage that although they can do multiple claims throughout a tenancy, they hold on to at least half of that $5,000, $2,500 or so, just so that they're protected at move-out with a major expense. What do they need? They need that statewide vendor ID number again. They need a subsidy program inspection report, written rental agreement, a move-in condition report signed by the tenant and landlord. That's an important one and the number one reason for denial in the program. Proof of subsidy payments before photos of damages and repairs I can do a claim without the photos if the receipts and invoices tell me the whole story. So if, for instance, they're replacing appliances, I need to know absolutely how the tenant damaged those appliances. I am pretty picky on these claims, and I will go through them with a fine-tooth comb and ensure that the charges being charged are for tenant-caused damages. Notice this to tenants for unpaid charges included in the claim. This is my aha moment. This is where we start talking about other things aside from damages that can be claimed, and I'll go into that in a moment. But then you can complete that online claim form if the landlord has all that together and submit for reimbursement. So damages included, but are not limited to physical damages. This is very true in this program. The program will cover late charges, non-compliance charges, legal expenses, and utility charges, and will cover unpaid rent in the event that the tenant has vacated the unit. This program cannot be used to subsidize rent, so the tenant has to vacate the unit before we can pay unpaid rent, and we'll pay for unpaid rent up to the date the tenant vacates the unit. We won't cover lease break charges or rent responsibility or deposit forfeiture. I'll back all those out of a claim so that we can actually adjust it down to a tenant damage claim, plus these items that are included. So what's the difference between a housing inspection report and a move-in condition report? It's a pretty dramatic difference, actually. The housing inspection report looks for habitability only and structural integrity. That's done by an inspector, by the subsidy provider. The move-in condition report is where the tenant has the ability to note the minor dings, marks, and damages in the unit that are pre-existing at the time of move-in. This needs to be executed by the tenant at the time of move-in. The only exception I provide for that is if a landlord purchases a property and the previous owner did not get move-in condition reports. If they do an inspection at the time of purchase or relatively close to the time of purchase, I'll accept that, although it may not be a legal document as far as the security deposit RCW is concerned, because those are a move-in condition report is required if a landlord holds a deposit or charges against a deposit in the state of Washington. If they don't have that, they're supposed to refund the entire deposit immediately upon discovery. But both documents are required for the claim. Now, when can they submit a claim? A landlord can submit a claim the day the tenant enters the unit for that $1,000 reimbursement for modifications, all the way through tenancy and up to 1 year after tenancy, so long as each individual claim exceeds $500 and the combination of all claims does not exceed $5,000. And again, when they start dipping into that $5,000, if they receive any portion of that back, they cannot take legal action against that tenant for damages. And how long does the process take? This is true on the TPP, the Tenancy Preservation Program, and the Landlord Mitigation Program. Once they complete their online submission form, they'll receive an automatic notification that it was successfully submitted, and then I'll review it within about 3 business days right now. I have up to 10 business days, but the turnaround's within 2 or 3 business days. And then funds will be dispersed upon approval and fund availability. And right now we're looking about 4 to 5 weeks out for payments to be received by landlords. This can be extended, although we have a permanent funding source through the document recording fees. Our spending's exceeding the income a little bit right now, and I know we've got some measures going through right now to get some allocations from the Senate, which will help for the remainder of the year. And then claimants of denied claims will be notified immediately upon decision. Typically, I don't deny a claim. I'll kick it back to the landlord, telling them what I need to approve the claim, and I'll work with them to get that claim approved. But if they can't provide the documents, it's going to end up being a denied claim. And the next question is whether or not you can appeal a denial, and the answer is no. As far as denials go, once it's denied, absolutely denied, and the landlord cannot provide the documentation or photos or information that's required to pass it, there's no appeal process, except that a landlord can go to a court, get a judgment against the tenant, and submit that, and under the RCW, I would be subject to award that claim up to $5,000. Now that's the presentation as a whole. I'm going to go back here for a second and click on one link because I want to share some data with you. Well, I'll just open it up here.
We also have questions, Nick. We also have questions in the question box. So when you're ready.
Oh, yeah, quite a few.
All right. So the first one is from Jenny Wildly, and she says, for the tenant preservation program, are there any interest or other fees for the loan?
No, there is no interest. There are no fees. The tenant will need to make payments to the county, the Superior Court clerk, wherever their judgment was filed at. And those funds will be sent to Commerce directly. There's no point of contact at Commerce that they'll have, though they will want to go to the courthouse to make those payments. But again, no interest, no fees.
All right. Taffy Wielden says, we are a nonprofit organization that is contracted to provide permanent supportive housing utilizing HUD COC funds. Our agency master leases units from private landlords, then sublease the units to program participants. Is our agency eligible to utilize the Landlord Mitigation Program to recover costs for damages by program participants?
Yes, master leasers are eligible for the program. The master leaser and the landlord will have to determine how they want to do the statewide vendor ID number set up, but so long as the lease includes the master leaser as the lessor or the landlord, then absolutely.
All right. people are also asking is, are the slides going to be available after the presentation, and are they printable?
Yes, as a matter of fact, the site, you should be able to see my web page here. I'm just going to double check real quick. Yeah. So the website itself has a printable version of the presentation without the tiger slide on it. And that is located right below the reimbursement button, towards the end, mitigation training presentation. It's in PDF form. You're welcome to print it out. And if you do want a presentation at a location, simply contact me. We can arrange something, especially if you're putting landlords in a room. I'd love to talk to them about it.
All right. And Misha Vergara says, thanks for saying it's uncommon. I think she was referring to the damages. Please try not to vilify these low-income clients. They are dealing with trauma and discrimination on a constant basis in transitioning back into stable housing. Jamie Million asks, is there any vacancy loss eligible to claim? And then gives an example in situations where after the tenant moves out, where damages take extra time to repair and prep the unit for a new move-in.
Sure. This question has come up before with landlords through the program, and the answer is no. The rent responsibility cannot be covered by not the rent responsibility, but the rent loss between units cannot be covered by the program, because that's a variable number, and ultimately we can't be held accountable to the vendor time periods for repairs or the landlord's time frame, because they may not have the budget in hand to make the repairs at the time. So rent loss is really not something that can be considered here. It is covered in the first portion, that $1,000 reimbursement portion, where they take time to make the repairs, and that's limited to 14 days.
And I don't know if this is relevant after that, but the next one was from Jamie Million again, and says this is also in context of new move in being subsidized / nonprofit PM for supportive housing.
I'm sorry, maybe I didn't understand the full question there.
I'm not sure I understand it either. Let me see if I can unmute Jamie. See if I can find. There we go. Jamie, I'm going to try to unmute you. Can you
Hi, can you
speak?
hear me?
Yes, we can hear you.
Okay, cool. I didn't know if my mic would work. Yeah, sorry that was not written in a super great way, but so I'm working at a nonprofit where we do a master lease program, and so we're paying out funds to initially lease units, and then so the vacancy loss piece is that we're paying out funds to keep these units available so that we can put in clients that are part of our permanent supportive housing program. And so I've gotten some mixed messaging on whether or not vacancy loss in that context is eligible. So that's why I was asking that question, trying to provide a little more context on that.
Thank you for the clarification. No, rent loss would not be considered reimbursable under this program for that purpose. The only time rent loss can be considered is if modifications or repairs are made to pass an inspection. And I should state pass a failed inspection on that as well. That's the only time rent loss can actually be reimbursed.
Okay, thanks for the clarity.
Mm-hmm. Sure. Are there any other questions there? I'm not sure where you were on the list there.
We're done with the questions. One person did say thank you for doing this webinar, and they're
Sure.
affiliated with NAMI.
So before I end this presentation portion, I did want to make sure everyone's aware of the legislation that's on the table right now that is affecting the Landlord Mitigation Program. Some good stuff is on the table. First off, we have the expansion of the Landlord Mitigation Program to assist with persons fleeing or victims or survivors of domestic violence. We already have the ability to provide this to subsidized tenants, but this 2520 will expand this to non-subsidized tenants as well. So the legislature is passing a bill or attempting to pass a bill that says that the landlord, in these cases, the landlord should be refunding the entire security deposit and then applying for reimbursement through the program. We do have a system in place to help mask the identity. It does, at this point, it does require an HMIS registration. So if you do have any tenants that are trying to vacate for domestic violence reasons, collect their HMIS registration number so I can verify they're an actual person in your claim, and then redact all of the information on the paperwork, and you'll be able to submit that to me. But we'll have a conversation one-on-one, hopefully, before you submit, so I can give you better instructions on how to do this. But there are options in those scenarios. The new one that we're talking about yesterday here in Commerce is 1694, which is something that they're asking that landlords, or they're going to require landlords to break up or give the tenant the ability to break up the move-in costs into 3 monthly installments. And if that tenant is low income, low resource, or in a temporary financial hardship, they may become eligible for reimbursement if they aren't able to make those payments through the Landlord Mitigation Program and maintain their tenancy. And there's a few other initiatives out there as well, but those are the two big ones right now. Thank you, everybody, for joining us and for paying attention to the Landlord Mitigation Program and showing interest in it. If you have any questions at all, don't hesitate to email me. The website has a lot of information on it and FAQ pages, but my email's there as well. So do feel free to reach out and let me know if you need assistance with it.
Thank you, Nick, and thank you everyone for attending, and we'll see you next month.
Cheers.